On September 3, 1587, a court-appointed lawyer named Antoine Filiol stood before an ecclesiastical judge in the Alps and rejected a settlement offer on behalf of his clients, a swarm of green insects devouring the local vineyards. His argument? The land the villagers proposed to give the bugs was, quote, sterile and neither sufficiently nor suitably supplied with food for the support of the said animals. Experts had been sent to inspect the site. He filed his objection and demanded the whole case be thrown out with costs against the villagers, and the court agreed to hear more arguments. This is not a joke. The paperwork survives, 29 leaves of it, and the story behind it is stranger than the internet version you've probably heard. Here's the version that floats around online. A French town got so fed up with caterpillars eating their crops that they hauled the caterpillars into a church court, gave them a lawyer, held a full trial, and excommunicated them. It sounds like the perfect medieval absurdity. Superstitious peasants, pompous clergy, bugs standing trial. Great story. And almost every detail in that version is either wrong or stitched together from different events across different centuries. Let's start with the easy corrections. The town wasn't in France. The defendants weren't caterpillars, and whether anyone was actually excommunicated at the end, well, nobody knows, because the record trails off into expense entries. The real case happened in Saint-Julien, a wine-growing hamlet in the Maurienne Valley on the road over the Mont-Cenis Pass in the Duchy of Savoy, which didn't become part of France until 1860. The case was heard by the church court of the nearby bishop city, Saint-Jean-de-Maurienne. The insects were not caterpillars, but small green flying creatures the locals called verpillions, amblevins or bêches. Evans identifies them as a greenish weevil, Rhynchites auratus. And the proceedings weren't a quick spectacle. They dragged on for more than 8 months, through adjournments, legal briefs, a site inspection, and, I am not making this up, a delay caused by a duke's army marching through the mountain pass. Now, caterpillar excommunications did happen, or at least were reported. According to a much later French account, a bishop of Lyon pronounced against caterpillars and field mice in 1120. 19th century compilations record that in 1516 an officer in Troyes issued a formal admonition ordering caterpillars to leave within 6 days or be pronounced accursed and excommunicated. In 1585, the Grand Vicar of Valence is said to have ordered caterpillars out of his diocese. But these were decrees, short pronouncements, not adversarial trials with assigned counsel and pleadings. The full courtroom drama with lawyers arguing and judges deliberating. That's Saint-Julien. And it's about weevils. The Saint-Julien saga actually begins 42 years before Filiol's famous objection. In 1545, the wine growers of Saint-Julien brought their first complaint before the ecclesiastical court of the Maurienne. Their vineyards were being destroyed. They wanted the church to do something about it. The court took this seriously. The complaint was made before François Bonivard, Doctor of Laws. A procurator named Pierre Falcon and an advocate named Claude Morel defended the insects. Pierre Ducol appeared for the plaintiffs, the villagers. What the surviving record of 1887 tells us for certain is only that the earlier proceeding happened and that the scourge ceased for a generation. The familiar details, that the presiding cleric refused to punish the weevils as agents of divine retribution, that the villagers were told to repent, pay overdue tithes and attend 3 special masses, and that the insects then departed, come from later retellings rather than from the Latin record itself. Treat that as the story as it's usually told, not as documented fact. What is documented is the logic behind the whole affair, and it's the important part. The court wasn't treating the bugs as criminals, it was treating the infestation as a spiritual problem, and the villagers as the ones who might need correcting. 42 years later, the weevils came back, or new ones did. Either way, on April 13, 1587, the syndics François Amenet and Pétremont Bertrand appeared before the court of the Prince Bishop of Maurienne, or, as the record puts it, his vicar general and official, and filed a new complaint in the name of the inhabitants of Saint-Julien. Their petition survives, and it's remarkably self-aware. It reads, in part, "Formerly, by virtue of divine services and earnest supplications, the scourge and inordinate fury of the aforesaid animals did cease. Now they have resumed their depredations and are doing incalculable injury. Then this extraordinary sentence: if the sins of men are the cause of this evil, it behoveth the representatives of Christ on earth to prescribe such measures as may be appropriate to appease the divine wrath. They aren't saying the bugs are evil. They're saying maybe we are, and we need the church to figure out the right remedy. The same petition asked the court to appoint fresh counsel for the insects, because the lawyers from 1545, Falcon and Morel, were both dead. So the court appointed a new defense team, the procurator Antoine Filiol at a moderate fee and the advocate Pierre Rambaud. From this point forward, the trial becomes a genuine legal proceeding, with all the procedural slowness that implies. The parties appeared on the 30th of May. The case was adjourned to the 6th of June, when Rambaud filed his answer, arguing that the villagers' action could not be maintained and that they should be non-suited. In July, the plaintiff's side kept asking for new terms. The record suggests they were happy to let the suit run. Then the community tried to settle, and Filiol asked for a copy of the official record and time to deliberate. The court adjourned to the first juridical day after the harvest vacation, the 11th of August, and then by consent of both parties to the 20th. Then something genuinely surreal happened. Charles Emmanuel I, Duke of Savoy, was preparing to invade the Marquisate of Saluzzo, and troops were moving over the Mont Cenis Pass, right past the valley. The Latin record notes the delay with the phrase actento transitu armigerorum, the passage of armed men still going on. The bug trial was postponed to August 27th and then to September 3rd because the soldiers kept coming. When the trial resumed, the insect's defense had already made an argument that was both legally creative and theologically grounded. Their core claim: these creatures were created before man. God blessed them. In Genesis, God granted every living thing, every green herb for meat. The weevils were therefore exercising a divine right. They were God's creatures, placed on the earth before humans, and they were eating what God told them they could eat. This wasn't just rhetoric, it was a genuine legal problem for the court. If you accept that God created all creatures with purpose, then destroying or excommunicating them raises uncomfortable questions about overriding divine will. The villagers, trying to resolve things, proposed a compromise. On the 29th of June, summoned by the church bell to the square after Mass, the whole community voted to set aside a specific plot of land, a place called La Grande Face, as a permanent reserve for the insects. The record describes it with the precision of a survey. The villagers reserved a right-of-way across it, the use of its springs, the right to work its ochre mines, and the right to shelter there in time of war. All, the document says, without prejudice to the pasture of the said animals. If the weevils returned to the vineyards after that, the court could proceed with excommunication. Filiol rejected the offer. The land, he said, was sterile and could not support his clients. He asked that the proposal be thrown out and the action dismissed with costs against the villagers. Bertrand, for the plaintiffs, flatly denied it, insisting the spot was admirably suited, full of trees and shrubs, and the file's closing accounts include 3 florins paid to experts appointed to visit the place assigned to the insects. A real site inspection, itemized. A court-appointed lawyer, representing bugs, rejected a settlement on the grounds that the real estate wasn't good enough. In 1587, with receipts. Here is where the story gets honestly uncertain, and I think the uncertainty is more interesting than any clean ending would be. The trial record runs to 29 leaves of Latin, under a title that translates roughly as "The Acts of the Syndics of the Community of Saint-Julien against the brute animals in the form of flying insects, green in color, commonly called verpillions or amblevins." Evans reports that the documents were still preserved in the commune's archives in his own day, and that they were communicated by the commune secretary Victor d'Albane to Léon Menabrea, who printed them in 1846 in a volume published at Chambéry, drawn from the memoirs of the Royal Academic Society of Savoy. E.P. Evans summarized and translated much of it in his 1906 book, The Criminal Prosecution and Capital Punishment of Animals, which is how almost everyone since has encountered the case. The last entries in the record are dated December 20th, 1587. 8 months after the case opened. They are expenses: 3 florins to the experts for the site visit, 16 florins for clerical work including seals, 3 florins as a gratuity for the vicar. That's it. No verdict, no excommunication, no dramatic climax. Evans himself flagged the outcome as doubtful. No judgment survives in the file. You may have heard the punchline that the last page of the verdict was eaten by insects. It's a fantastic story. I can't find it in Evans or in any archival source, and no contemporary record says any such thing. It may be true, it may be legend, and it may be the kind of detail that's too perfect not to repeat, which is exactly why I'm not going to present it as fact. The German legal historian Karl von Amira, writing in 1891, drew a distinction that makes the whole tradition click. And Evans quotes it approvingly. There were 2 completely different kinds of animal proceedings in medieval and early modern Europe. Secular courts tried individual domestic animals, pigs, cows, horses, for killing people and executed them. Ecclesiastical courts dealt with swarms: rats, mice, locusts, weevils, caterpillars. The remedy there wasn't execution. It was exorcism, admonition or excommunication to drive the creatures out of the fields. One system treated an animal as a murderer. The other treated an infestation as a spiritual crisis. Evans's chronological list runs to something close to 200 entries, from the 9th century to the 19th, with the heaviest concentration in the 15th, 16th and 17th centuries. That's a list of reported cases collected by one Victorian scholar, not a census of everything that happened, but it shows a real pattern, and communities paid real money for these interventions. Evans records that in 1660, Lucerne paid 4 pistoles and a Roman thaler for an anathema, and that in 1731, the Municipal Council of Thonon in Savoy resolved to join with neighboring parishes to obtain an excommunication against insects from Rome, with the expenses split proportionally. These weren't eccentric one-offs. They were a recognized service with fee schedules. It's easy to laugh at this from the 21st century. Evans largely did. He wrote as a man convinced he was describing ignorance governed by brute force. But that's 1906 editorializing, and it misses something. Modern historians tend to read these proceedings as ritual and liturgical acts as much as legal ones. They enforced community discipline, they encouraged tithes, and they gave people a structured response to crop failure in a world without pesticides or crop insurance. The bug's lawyer wasn't a joke. He was a pressure valve, a way to make the process feel legitimate so the community would accept whatever remedy the court prescribed. The weevils of Saint-Julien never got a verdict, as far as anyone can tell. But 29 leaves of Latin, 8 months of adjournments, a duke's army on the march, a rejected land deal, and a 3 florin gratuity for the vicar suggest that the people involved took this very seriously, and maybe understood something about institutional ritual that we've only recently started to appreciate again. If this story made you think differently about what counts as a legal system, or what counts as rationale, this channel has more where that came from. Stick around.